I am very happy to have the opportunity to join you. I'm sorry that I can't be there in person. The slideshow hiccup would have been a lot easier to manage in person as well, but I'm glad to have the opportunity to talk to you. The panel title is I think, very timely in the sense that we're grappling with how to accelerate action under the Paris Agreement on climate change. And as that grappling is happening, we've seen an increasing turn to international courts and tribunals. And in one way or another, it seems to me that one of the oldest rules of international environmental law, in fact, one might say its point of origin, is playing a central role in those proceedings. And that's the harm prevention rule, and along with it, the requirements of due diligence. And what I'm hoping to do is to give you a short sketch of the evolution of this principle and the due diligence requirement over time. And that is, first of all, an evolution from what you might refer to as the no harm rule to what I think is now clearly understood to be a harm prevention rule. And then along the way, an increasing texture that has been added to the notion of due diligence. And it's interesting that this development has been done in significant part by international courts and tribunals, of course, also to some extent by the International Law Commission. But it's interesting that courts and tribunals play this relatively significant role, given that they have not tended to be a major arena for international environmental law through most of its development. And so what I want to do is trace some of the key steps in this journey and illustrate how a very old rule is proving to be pivotal in a changing world. And so with that, I guess if we go all the way back, international environmental law originated in a kind of international neighborhood law, international nuisance law. I think that's actually quite comparable to how domestic environmental law evolved. And that entailed then thinking of transboundary impacts as interferences with sovereign rights and finding rules, articulating principles that help us balance the territorial sovereignty of one state with the territorial integrity of another state. And that in turn led to this notion that states' right to use their territory and resources is limited by the obligation to avoid significant transboundary harm. And this no harm rule was, as you all know, first articulated in an arbitral tribunal decision that involved transboundary air pollution. And it was articulated very much in keeping with what I've just said as thinking of an environmental impact in terms of harm or impact, injury to territory or property or persons therein. And at the time, that impact was thought to have to be of serious consequence and established by clear and convincing evidence. Over time, this rule got articulated in slightly broader terms as a responsibility to ensure that activities under jurisdiction or control do not cause damage. And here now we see to the environment, not strictly speaking the territory, and both of other states and of areas beyond the limits of national jurisdiction. And as a reflection on how relatively few occasions courts had to engage with this, it wasn't until 55 years after the point of origin in the Trail Smelter case that the ICJ had an opportunity in the Nuclear Weapons Advisory Opinion to confirm that this rule, as articulated in the Stockholm and Rio declarations, was a general obligation of states and a part of international law relating to the environment. And again, the ICJ confirming here that this is focused on respect for the environment, not just of other states, but also areas beyond national jurisdiction. And then if you think about the evolution of this rule, so let me just bring this up here. You can see quite clearly the shift from the focus on serious injury to territory, the need for clear and convincing evidence of the causal link between what happens in one state and the consequences in another. And also I want to suggest, even though that wasn't explicitly said, even at that time, this was a due diligence rule, so not an obligation to prevent harm at all cost. And that flows from the older principles of sovereign interest balancing that I refer to. Today, it's really clear that this is a rule to respect the environment of other states and areas beyond, that we have now a slightly different threshold, significant harm, so not the high level of serious harm. And what we need today, because the rule is focused on harm prevention, is evidence of risk. And it is risk that triggers due diligence obligations to act to responsibly to prevent harm and act in a way that is commensurate with that risk. And I am now going to talk a little bit more about what that, how that has taken shape. And so here now, the International Court of Justice did play quite a significant role. In this slide, I'm emphasizing for you that the court confirmed that this is a principle of prevention, and then goes on to say that it is incumbent upon state to avoid activities in the first place that may cause significant harm to the environment, and connects this principle of prevention to the previously articulated idea that states have that transboundary and global harm prevention obligation that was articulated in the Nuclear Weapons Advisory Opinion. Same quote, but now to highlight that the court also tells us that this rule is not new. It's old, as I've already said, and it's rooted in the due diligence that is required of a state in its territory. And you can see the green shading there. That will be familiar to all international lawyers, this language from the Corfu Channel case. So a reminder that this is a long-standing recognition of due diligence requirements. And then a little bit more here on what that entails. That is, the state has to use all means at their disposal in order to avoid causing significant environmental harm. So now, in the same decision, pulp mills, as you will all know, is a transboundary, so state to state harm situation. But the court takes the opportunity here to flesh out a bit more what due diligence requires. That is not just the adoption of appropriate rules and measures, but also a certain level of oversight. And we're being told here in part that this is not a one-shot obligation, but an ongoing obligation that that is entailed by the idea of harm prevention. And so if I put this, and I'll put this all up here in slightly more abstract terms, what we've learned over time is that due diligence is at once substantive. That is, what are the reasonable measures required to prevent transboundary harm, including, for example, enacting appropriate laws and policies, but also very much procedural. So if the goal is to prevent harm, a number of things have to be done by states that in advance of determining what appropriate measures might be. And the last one I highlighted for you because that is environmental impact assessment. That's because also in the pulp mills case, the International Court of Justice confirmed that a new procedural obligation had entered the orbit of rules binding under general international law, and that is the requirement to undertake an environmental impact assessment where there is a risk that significant transboundary harm might be caused. So again, here the connection to the risk. The risk triggers the obligations. We don't wait until harm is caused. We're not looking backwards, although of course that could be where harm has been caused, of course, that would be something that could be undertaken as well. But the focus in the harm prevention rule is before. And so we're being told here again also that due diligence is key, and due diligence would not be considered to have been exercised if an environmental impact assessment to ascertain precisely whether and what kind of risk there is not undertaken. And 5 years later, in the Costa Rica, Nicaragua cases, the ICJ again connects this to due diligence. It states very clearly that this happens before we ever even undertake the activity. The point is to ascertain if there is a risk in the first place and what kind of risk, and then confirms that if the EIA does confirm that there is such a risk, then a range of other procedural obligations kick in to engage with the neighboring state in good faith. So here we are in both of these cases so far in a transboundary context. And that is why the advisory opinion of the International Tribunal of the Law of the Sea that was already mentioned a moment ago is so significant because it is significant for a whole range of reasons, but it brings this conversation into a global context and into the context of the environment as a whole, including in areas beyond national jurisdiction. So I won't go into the questions put to the tribunal in the law of the sea context. For my purposes, what's interesting is that these obligations are reflective of the more general harm prevention rule that I've talked about, and so therefore gave the tribunal an opportunity to speak to harm prevention and due diligence. And so in this advisory opinion, the tribunal says, first of all, of course, prevention is not an absolute obligation. It is an obligation to act with due diligence, but lest one thinks that that means that states can just do as they please. Far from it. We're learning, or we find confirmation here in this advisory opinion, and I can't stress how important that is, including for potential attempts to invoke the responsibility of a state, that this is a fairly specific, depending on the circumstances, and quite stringent obligation. So the tribunal here, in the quote at the bottom, reiterates what the ICJ had previously said in the pulp mills case, but then went on to say that, and again, none of this is new, but it is very helpful to have it set out this clearly, that due diligence is a contextual, a variable standard. What it requires, how stringent it is, depends on what kind of scientific information we have, what risk there is of harm, how severe the potential harm is, how urgent the situation is, and so on. So that means the more all of these circumstances go up, the more stringent the standard. And inherent in this, also really importantly, remember my starting point, old rule for a changing world. We see here that the due diligence standard is inherently suited to that changing world because it changes over time. Similarly important, the tribunal tells us that this is not just up to states to do as they please, as I already said. It's not complete discretion. There are objective standards that are given to us by scientific evidence and international rules and standards, and the tribunal here in the climate context in particular points to the 1.5 degree temperature goal that is globally accepted today and has been affirmed, including in the context of the Paris Agreement. And for good measure, it's being confirmed that this standard of due diligence is stringent, given the high risks and serious and, in fact, irreversible harm that climate change occasions. And of course, again, as the previous speaker highlighted very importantly, what exactly due diligence requires of states is also dependent, again, objectively determined by states' capabilities and available resources. So it's not necessarily the same degree of obligation for all states. Very briefly, this was also alluded to, and for my purposes, there's lots that's being put to the International Court of Justice in the General Assembly's advisory opinion request, and the hearing before the International Court of Justice will be in December of this year. And to underscore how interested states are and what is on the table here in terms of international legal obligations, some 90 states have made submissions to the court. And for my purposes here, key, again, the duty of due diligence and the principle of prevention takes center stage. Interestingly, the ICJ is squarely being asked, what does this mean, not just for harm to states, but for harm to the climate system and to the environment that we all share globally, and then following from there, what might be the consequences with respect to harm to individual states. Before I conclude, just to flag something that most of you probably also know, there is also an advisory opinion request. I'm almost done. Thank you. There's also an advisory opinion request before the Inter-American Court of Human Rights, which also features a dimension of due diligence, albeit in a slightly different context. The question here is whether the due diligence that states owe in managing activities under their jurisdiction and control can lead to human rights obligations being owed to states in another country. So in short, I think this is a major moment in the development of international environmental law. And it seems to me it is interesting that much of the action here, as I see it, is not so much about the development of new rules and principles, but about the development of one of the oldest principles of international environmental law in the books, which is precisely via due diligence proving to be highly adaptable and I am hoping highly capable to help us. Thank you very much.